Good evening to all the participants. On behalf of CNICA, I extend my wishes and warm welcome to all the participants for today's study series. As always, you have been a wonderful source of support and inspiration for CNICA to conduct the study series. Human beings do not always make rational decisions, but human irrationality can be predicted. If irrationality can be predicted, then machines can be used to perform tasks that require human intelligence. Artificial intelligence is nothing but technology having human capabilities of performing tasks that require human intelligence. It is interesting that almost 6.5 decades back, which is in 1955, an American computer scientist, John McCarthy, suggested the term artificial intelligence in a research project proposal, which described AI as a problem of making a machine behave in ways that would be called intelligent if a human were so behaving. The use and impact of AI on legal profession is slowly becoming a hot topic in legal, technology, and academic circle. A significant amount of legal research and document review has now shifted from libraries and client basement archives onto online platforms. A number of AI-powered products and services already exist to help lawyers pass through submissions, identify better legal authorities, review documents and agreements, and predict outcomes. Although international arbitration, forming part of legal service industry, has been so far practically unaffected by such developments, nevertheless, AI has already moved into international arbitration with incipient but positive steps, with the aim to lighten workloads and assist the work of various players in the arbitration arena. International arbitration community has been improving its services through implementation of new IT-enabled services such as video conferencing, e-disclosure, use of online platform, and cloud-based technologies. Artificial intelligence is already making its presence felt in international arbitration by implementation of niche technology in arbitration process such as speech recognition, transcripts, interpretation, and translation. However, these and other similar steps are improvements of an increment nature well known to most and successfully practiced by many arbitration practitioners and institutions. The topic amalgamation of artificial intelligence and international arbitration is intuitively interesting. Vertiginous advances in AI has already created caution, concern, and wider debate in legal firmament over the potential benefit versus risk of applying AI to IA. Conferences in international arbitration sphere have begun to address how AI and IA alliance could play out in practice. We have with us today an erudite lawyer, a person of conspicuous ability and skillful practitioner in Mr. Ramanathan Chinniah, a barrister and a solicitor of High Court of New Zealand. He is an accomplished and mellifluous speaker and will enliven the topic, a forward on amalgamation of artificial intelligence and international arbitration. May I request a chairperson, Saranan, to welcome today's speaker. Over to you, Saranan.
Thank you, Ashok. Thank you, Mr. Anand, for your wonderful welcome address. Good evening to one and all, and my warm wishes on behalf of CNICA. In the legal profession, artificial intelligence is finding its way to support lawyers and clients alike. The growing interest in applying artificial intelligence in law is slowly transforming the legal profession. Realizing the rise of artificial intelligence in the legal profession in general and international arbitration in particular, we thought that we can discuss the different ways in which the artificial intelligence is currently applied in the legal profession. Today, we have with us the resource person, Mr. Ramanathan Chinniah. Mr. Ramanathan Chinniah is an enrolled barrister and solicitor of the High Court of New Zealand and over 5 years of top-notch legal experience in consulting, advising, and researching into niche areas such as artificial intelligence law and space law. He has been awarded with Masters of Law degree by the London School of Economics and Political Science, drawing appreciation for a novel and a highly interesting complex research paper. Ramanathan is highly proficient in the corporate and commercial laws of various jurisdictions, including England and Wales, New York State, New Zealand, Australia, European Union, Canada, Singapore, Malaysia, and South Africa. He has been part of pioneering efforts in the setting up of virtual legal offices and alternative legal solutions companies that bring together lawyers from different jurisdictions to advise on cross-border issues. He has co-founded and set up the first successful student-led pro bono legal advisory unit as part of the University of Manchester. Mr. Ramanathan has completed nearly 1,000 legal consultant and research briefs within 4 years and have consulted for commercial and high net worth private clients from across the world. He has experience in wide areas of practice, including corporate, commercial, white-collar crime, private international law, public international law, human rights law, and international arbitration. Mr. Ramanathan has been described by virtual legal offices and alternative legal solutions companies as having an excellent range of knowledge on law that he has begun to hone and refine. Mr. Ramanathan has recently completed the New York bar and awaiting admission in the state of New York Supreme Court. On behalf of CNICA and all the participants, I wish Mr. Ramanathan all the very best to his future endeavors. And now I request Mr. Ramanathan to deliver his presentation. Thank you so much.
Mr. Ramanathan, you need.
Can you hear me now?
Yes.
Perfect. Good evening to everybody. Sorry, there was a technical glitch there. I was muted along with all of you. So my name is Ramanathan. I go by Rama. And I know Mr. Saravanan, Mr. Anand, and Mr. Ashok Pati for the last 2 years. And this is my second study series lecture with them. The first one was held over a year ago in Chennai in a convention hall. And I was facing a group of lawyers and I was presenting a topic on artificial intelligence. And today I'm sitting in my home office, facing my computer screen and connecting with lawyers from different parts of the country and the world. So this really shows you the power of technology and the way it augments your professional and personal life. And that's the spirit of the topic today, how we can use, or can we even use artificial intelligence to improve international arbitration. Now, before I start on my lecture, I would like to speak very briefly about CNICA. And firstly, that was a very insightful forward by Mr. Anand. I think it was a well-researched piece. He went all the way back to 1956. And Mr. Saravanan gave me a very lively introduction. I hope I live up to that. So what CNICA is doing right now, it is quite impressive because we live in an extremely precarious, challenging times with COVID-19. Everybody's become so afraid and we're so panic-stricken as a species. The global numbers of deaths and infections are staggering. So when you have organizations like CNICA come forward and they organize webinars, it helps to remove our mind from the dangers of COVID-19 and start focusing on the finer aspects of our profession so that once we are past COVID-19, we're not left behind as compared to our international counterparts. So really thank you so much, CNICA, for this amazing opportunity. And I hope to be giving you a very insightful presentation today. Right, so the topic that we're going to be focusing on is the amalgamation of artificial intelligence in international arbitration. And I'll split up this lecture into 5 main parts. The first part, I'll give you a brief overview of artificial intelligence. And after which, I'll talk about how AI can impact on the peripheral aspects of arbitration. And then we'll talk about the limitations of applying AI in the peripheral aspects of arbitration. The fourth part, we will talk about if AI can perform the role of an arbitrator. And finally, I'll close off the lecture with some of my personal comments outside of my professional research. So I'm going to try and do a screen sharing. Just give me a quick minute. Right. Okay. Can you see me?
Yeah, the screen is shared. You need to.
Okay. Right. Okay. Great. So now the first part of the lecture, overview of artificial intelligence. Lawyers and professionals from across the world, they tend to lack a basic understanding of what AI really stands for. A lot of our understanding is influenced by pop culture and movies and what we think AI should be versus what AI really is. So let me set out two definitions that we can run by for today's lecture. The first definition, AI can be defined as making a machine behave in ways that would be called intelligent if a human being was so behaving. A second definition about intelligence is that intelligence is the ability to learn, understand, and make judgments or have opinions that are based on reason. Now, there's been a paradigm shift in artificial intelligence in the last few years, thanks to what we call a data quake. There's been an emergence of huge amounts of data due to the combination of Moore's law and Critter's law. So Moore's law states that your computer's processing power doubles for every 12 to 18 months. And Critter's law states that proportionately and approximately, the cost of storing data falls for every 12 to 18 months. So a combination of these two has led to what we call big data. Now, big data has changed the way artificial intelligence is being developed today across the world. Previously, what happened was you have programmers and computer scientists trying to develop complex algorithms which they program into a computer, and by virtue of that algorithm, the computer starts behaving intelligently. But what happens today is that a machine is fed large volumes of data, and the machine learns from that data, what we call machine learning. So machine learning is a subfield of artificial intelligence, and it's concerned with computer programs which learn from their experience and improve their performance over time. So it's not static, but dynamic. The machine that we're talking about can change the way it's behaving over time. Also, at the very core of machine learning, there's the inference of hidden factors and patterns from observed data. So in the AI context, what really happens today is that you have a program and it's fed large volumes of data, and the program tries to find out an accurate model, which then it can apply to all future cases accurately. A simple example would be how your email application now identifies spam emails automatically without you marking them as junk. So in many cases, AI today produces very intelligent outcomes, which when performed by humans, it's thought to involve high levels of cognitive processes. But in my opinion, and as we're going to see, the result that is being achieved is anything but resembling of human cognitive processes and human intelligence. What really happens in today's times is that artificial intelligence develops along probability as opposed to like intelligence as we understand it. Now, the last thing I want to tell you about artificial intelligence for today's lecture is that there is no one form of AI. If you go to the internet and you look for companies that are dishing out AI softwares for law firms, you would find like 30, 40, 50, 60 companies with 50, 60 different types of softwares. So artificial intelligence is not one type of machine, but it's a broad umbrella under which multiple types of machines are being developed. But for the purposes of our lecture, I think we can classify them into two main ways. The first model is what we call the expert model. It's rule-based, and it uses logic as the normative principle. Now, these models apply to pre-established data, and they try to come up with a model which applies in the future. And then you've got the machine learning model, which has no predefined rules, but it uses pattern recognition, and it's built on probabilistic model. Now, this method is predictive. It helps the lawyer to calculate the likelihood of outcome, a positive or negative outcome in an arbitration proceeding or in a domestic litigation. So that's pretty much all that you need to know about AI for the purposes of this lecture. It's a broad topic. I really think you should study more about it yourself as well. But for now, I think that's all I would like to tell you. Now, let's move on to arbitration. When I'm talking about the core and peripheral aspects of arbitration, and let me explain my terminology here. When I talk about the core aspect of arbitration, I'm talking about the process of dispute resolution. The very purpose of arbitration is to ensure that a dispute between two parties, commercial or state and commercial parties, is resolved. So what happens is that you have a panel of arbitrators. They hear the facts of the case, they apply the law, they issue a judgment and an award, and hopefully the dispute is resolved. When I talk about the peripheral aspects of arbitration, I'm talking about all of the legal and administrative procedures that assist these arbitrators in reaching an outcome. So for example, the selection of arbitrators, document requests, document review, all of these would be peripheral aspects of arbitration. They are legal procedures and they are quite essential for the smooth functioning of arbitration, but they don't exactly lead to the resolution of the dispute. So what I'm going to do today is that I'm going to talk to you about how AI can be implemented in the peripheral aspects of arbitration, and then I'll talk to you about the core aspects. Now, if you look at researchers and experts like Richard Susskind and Philip Hank, they have talked about how AI can be implemented in the peripheral aspects in multiple ways. And one of the most successful ways in which AI can be used by all of you law firms, arbitrators, tribunals, is predictive coding. Now, predictive coding is a form of supervised machine learning tool which takes human review-based data input about document relevance and applies it to a larger document population. Now, predictive coding is already being used in the US and English courts. In 2016, the BCLP law firm in the UK used predictive coding in the case of Brown and BCA Trading Limited successfully. So they obtained an order, in favor of their client. Now, in the US courts, in the case of Moore and Publicis Group, the judge went out of his way to mention that statistically, predictive coding review tends to be superior to traditional manual review of documents. So predictive coding has become increasingly a part of litigation, but arbitration is still a little slow to catch up. A survey done by Queen Mary University in 2018 shows that in the arbitration context, 5% of respondents use artificial intelligence occasionally, and 3% of respondents use them regularly. So one of the main reasons that arbitration is still not incorporating predictive coding is that nobody really is very clear on what predictive coding is and how it should be implemented. All the major arbitration institutions across the world, they don't have proper guidelines on how, say, predictive coding can be used. But a good start would be the International Bar Association's guide on technology resources for arbitration practitioners. So this guide mentions that predictive coding is a useful tool that arbitration lawyers should use for the purposes of document review. But the problem is that this guide, once again, falls short of explaining how exactly you go about using predictive coding. So let me run through a hypothetical example of how an arbitration lawyer can use predictive coding. So as all of you would know, arbitration involves large boxes and boxes of documents. And you need your lawyers and legal teams to go through these documents manually to find out which documents are relevant. Now, what happens in predictive coding is that you get a senior lawyer who's got a very good understanding of the dispute, and then you present a sample of the complete set of documents. Now, the senior lawyer goes through these sample set of documents, and he marks the documents as being relevant or responsive, irrelevant or non-responsive. And this information, this data is fed into the software, which develops an algorithm. And then this algorithm is applied to the entire document population. And it helps identify those documents which are relevant and responsive. So that's how predictive coding can be used in arbitration, in the peripheral aspects of arbitration. Now, predictive coding is potentially more efficient than a manual search terms-based review. Now, the reason for that is being that you don't have to hire out your legal team. Your legal team now has to just go through the documents which have been flagged as being relevant, as opposed to every single document in the box. Also, predictive coding is known to be of a higher level of consistency and therefore incurs a lower risk of error. Now, most of the international arbitral tribunals, they have rules which encourage arbitration lawyers and arbitrators to conduct the arbitration in a cost-efficient manner. So predictive coding can be used to help push down the costs that you incur when you arbitrate. The reason being is that you save on a large number of lawyer bills and lawyer hours. So that is the first way in which AI can be implemented in arbitration to our advantage. Now, AI can also be used to enhance the way adjudication occurs. Now, I'm not talking about the actual adjudication, but all of the processes which surround adjudication. So the first way in which that happens is that AI can be used to select the appropriate arbitrators for the dispute. Now, what happens is that when you have AI select the appropriate arbitrators, the lawyers can then identify the correct arguments at which they can mount with that particular arbitrator, and he's likely to accept that argument. So it sort of improves the quality of legal service that arbitration lawyers can provide their clients. A second,
Mr. Ramanathan, sorry for our interruption. Can you slightly raise your voice? We are getting a feedback that the voice is a little bit low.
Yeah, sure.
Okay, thank you. Thank you. Sorry for this.
No worries. Yeah, I hope I'm audible now, but if there's any problem, just pop in a message. So a related positive impact is that when you use AI to appoint arbitrators, you can overcome the long-standing issue of arbitrator bias and competence of arbitrators. Now, it has been shown statistically that bias on the part of the arbitrator is one of the main reasons that arbitration decisions can be incoherent, and the judgments sometimes lead to no resolution of the dispute. Now, the reason for this is that when you have a party-appointed arbitrator, or you just randomly select an arbitrator, the problem is that this arbitrator might have a preconceived notion on who should be winning the dispute, even before the dispute is properly arbitrated. Now, there are many international arbitration rules which guide you that an arbitration procedure, especially cross-border commercial arbitration, should be conducted in a completely equal manner. For example, Article 18 of the UNCITRAL Model Law states that there has to be equality in the adjudication service. So how AI can help you overcome the arbitrator bias is that AI would source and screen the decisions based on repeated tendencies of arbitrators when they're writing the judgments. And AI would help to flag and alter any of the tendencies which seem to be biased. Also, when you're recruiting arbitrators for your dispute, AI can be programmed to ignore any of the demographic data of the candidates, for example, the gender, sexual orientation, economic status, and so on. So any positive or negative associations that the arbitrators have with the demographic group could be neutralized. So that's one of the main ways in which AI can help with the selection of arbitrators. The second advantage is that of the speed of arbitration. As some of you would know, arbitration can be a lengthy procedure in terms of document review, contract review, and so on. So what AI can do is that it can help you speed up this process by performing some of the more rudimentary aspects of arbitration. The best example that I can give you here is that all 5 Magic Circle law firms in the UK and some white shoe firms in the US like Latham and Watkins, they have incorporated AI into their traditional model to help with document review. An example is the Kira Systems contract review program. And they have been using this now for the last 2 to 3 years to help speed up the process of dispute resolution, be it litigation or arbitration. Even in the emerging markets like China, AI has become an increasing norm in many of the law firms there. Thirdly, as some of you might have had the fortune or misfortune to read arbitration awards, they can be very long, especially in investment arbitration. So what AI can help you do is that it can generate an intelligent and the substance of the long award. And there are multiple benefits in such a generation. For example, you can save on arbitration costs by replacing tribunal secretaries with AI support systems. Secondly, it also helps with scholarly research into arbitration. Now, when you take law as a complete field, arbitration is one of the less studied aspects. The reason being is that many of the awards and the reasoning along with arbitration awards are confidential and they're not published. So when you have AI generate an intelligent synopsis, this can boost the way academics research into arbitration, and they can start pointing out trends in arbitration for you. Also, it can help with third-party funding when you have a synopsis. So third-party funding is increasingly becoming important in international arbitration. But the problem that these third-party funders face is that they're not sure of which arbitrations to fund. So when they have the synopsis, they tend to have a deeper understanding of the dispute, and they can choose which disputes that they want to fund. Finally, AI can also help with the automatic selection of your arbitral location. Take, for example, a unilateral arbitration agreement. So the AI system can automatically incorporate into the agreement that the arbitral location should be London instead of Paris, because in Paris, unilateral arbitration agreements are not recognized. So it's clear that AI can help with the tangential aspects of arbitration, as I've just described. But at the same time, there are multiple limitations that we should consider before we start believing that we can use AI to our advantage. Now, firstly, in international arbitration, document production obligations are typically sanctioned by ethical rules. So algorithms and software are not bound by ethics. Now, this raises the problem as to who would be responsible when the algorithm makes a mistake. Say, take predictive coding, for example. The software sometimes might include non-responsive and non-relevant documents that lawyers have to go through. But the bigger problem is that your software sometimes might miss out documents which are relevant. And if you don't follow up and recheck, and you just go with the documents that the software identified for you, there's a chance that you might lose the arbitration proceeding itself. So that is a costly mistake to make, because both in terms of ethics and economics. The whole point that so many parties are switching to arbitration today in cross-border disputes is that it is cheaper than cross-border litigation. But if you have such mistakes being brought about by artificial intelligence, the cost of your dispute goes up, because if you lose the proceeding, you're stuck with the award, and then you have to try and appeal against the award in the local courts. And you're not always allowed to appeal as well. So it is a costly mistake when a mistake does happen. Secondly, all of the benefits that I just described to you would only be viable if the AI technologies are affordable and a broad number of parties can incorporate that into arbitration. So affordability is a key point that we should take note of. As amazing as the benefits might seem to be, it's likely that only the wealthier parties to arbitration at present can afford artificial intelligence. So what happens is that when you incorporate AI into arbitration in the initial years, it would make the playing field in arbitration a very uneven one, as opposed to making it an even one. So the purpose of using AI is to make sure every party boosts their chances of winning the arbitration. But what really happens is that only one party can boost its chance. Take, for example, a Philippines company going up against the United Kingdom in investment arbitration. It's highly possible that UK can afford the resources and exploit AI technologies, but the Philippines company might not be able to. So affordability is a key limitation here. The third and the main limitation that we should take note of, and we're going to keep coming back to this throughout the lecture, is that of data. Now, AI is a very data-hungry creature. It requires large volumes of data before it can come up with an algorithm that lawyers can positively use. The problem is that arbitration is one of the most confidential parts of dispute resolution, as opposed to litigation, where you've got reports of cases being published every year. Artificial intelligence, at best, you've just got the outcome published. You don't have the awards or the legal reasoning published in many cases. It is true that in investor-state arbitration before the International Center for the Settlement of Investment Disputes, maritime arbitration before the Society of Maritime Arbitrators, and sports arbitration before the Court of Arbitration for Sport, they all publish unredacted awards in many instances. Also, you've got the International Court of Arbitration, the International Center for Dispute Resolution, Singapore International Arbitration Center, the Stockholm Chamber of Commerce, and the Milan Chamber of Arbitration. All of them do publish redacted versions of selected awards. But the problem is that for you to publish these awards, you need to have party permission and tribunal permission. So without securing this consent, you cannot publish these the awards and the outcomes. A prominent example I can give you here is that of Hong Kong International Arbitration Center and the Swiss Chambers Arbitration Institution, which by default avoid publishing any of their awards unless very strict consent requirements are met. There are a number of organizations today which are trying to bridge the gap here and increase the amount of data available in arbitration. Some of them are arbitrator intelligence, dispute resolution data, and the Global Arbitration Review Arbitrator Research Tool. So these companies and organizations are trying to increase the amount of data available, but the problem is that overall there's an abject scarcity of the data that's available. So the problem is that without having this data to feed into AI softwares, you cannot develop reliable algorithms that can be applied in arbitration. Now, what I'm saying here is that AI can be implemented in law firms and in the context of litigation, but in the context of arbitration where confidentiality is so highly respected, I think it is quite difficult at present to implement AI within arbitration. Fourthly, we've got data protection limitation. Now, once you start using such large volumes of data, there's a good chance that you need to start complying with the GDPR in Europe and other data protection laws. And as a number of you would know, complying with data protection laws is one of the largest contributors towards operational costs. So if you start implementing AI in arbitration, the possibility is that you have to start paying for compliance costs as well, which shoots up the cost of your arbitration. Secondly, you've got the issues of cybersecurity. In the case of Philippines versus China in 2015, in the Permanent Court of Arbitration, the Permanent Court's website was hacked and a lot of data was compromised. Similarly, in the case of Lebanenko versus the Republic of Turkey, the Republic of Turkey, they invaded and they intercepted communications between Lebanenko and its counsel under the guise of criminal investigation. So if you start using large volumes of data, it's also highly possible that you need to start having very expensive cybersecurity software installed in your firm and in your machines. So the point here is that while AI can help to reduce the costs involved in arbitration, on the other hand, complying with these laws and keeping the data secure can once again push up your costs. So it depends on like the size of the dispute and the size of your firm and how much you're being paid before you can decide whether it is a viable move to implement AI within arbitration. So that's what I've got about the peripheral aspects of arbitration. What we've seen is that AI has a number of advantages that we can reap, but at the same time, we need to be aware of all of these limitations. Now let's move on to the core part of arbitration. By the core part, I'm talking about arbitral legal decision-making and outcome prediction. Now, I am sure a number of you, or pretty much all of you, might have been impressed with what I've presented so far in terms of how technology can augment your arbitral process. But at the same time, I'm very sure very few of you would be so impressed to start thinking that technology has become more intelligent than the arbitrator. I'm sure most of you still see it as a tool that you can use as opposed to something that operates side by side with you. Let me give you a simple example. Compare 20 to 30 years ago when you had to place a phone call, you've got your landline phone, which is strapped to your desk, and today you've got your smartphone, which is infinitely more intelligent and performs exponentially more functions as compared to your landline phone. So everybody would agree that your smartphone is more intelligent than your landline phone, but I'm pretty sure nobody would agree that your smartphone is more intelligent than yourself. And that really is the core of what I'm going to talk about now. Me as a lawyer, and I'm sure most people, would only be impressed if AI can start performing the role of the arbitrator himself, instead of just helping us out with document review and selection of arbitrators and so on. So for us to see if AI can impact the core aspect of arbitration, I'm going to refer to two recent studies that have been conducted in Europe and the US, where they studied, where they used AI to predict the outcomes in courts. Now, the first study that I'm going to talk about is the European study, where in 2016, a group of researchers, they focused on the decisions by the European Court of Human Rights pertaining to three main articles. Article 3 of the ECHR, which prohibits torture, Article 6, which enshrines your right to a fair trial, and Article 8, which enshrines your right to a private and family life. So what they did is that they took a sample set of cases, they fed it to an algorithm, they trained the algorithm, and then they applied the algorithm to the rest of the cases, to a large body of cases. And the outcome was quite stunning. The model obtained an overall accuracy to predict the outcome of the court's decision in 79% of the cases. To break this down for you, the decision sections with the best predictive value were 76% for those cases which set out the factual circumstances, 73% for those which set out the procedural background, but only 62% for original outcome prediction. Now, the results here initially seem to be quite impressive and might be of use to lawyers in arbitration. But the problem here is that when the researchers fed the data to the algorithm, what they did is they gave the algorithm the legal reasoning of the courts as well. So imagine I walk up to you and I tell you, now this is the legal reasoning of the court. Now tell me if the court's gonna give me a positive judicial treatment or negative judicial treatment. I'm pretty sure everybody can do that. You don't need a machine to do that. So the problem is that this particular research that's been conducted, it's not exactly useful in proving that AI can be used for ex-ante outcome prediction. Now, the second study that I'm going to refer to is that conducted in the US, where a group of researchers studied US Supreme Court's decisions, and they published the results in 2017, just 2.5 years ago. So the study included US Supreme Court decisions from 1816 to 2015. That is 200 years of Supreme Court decisions. But instead of feeding the machine with the textual data, what they did is that they labeled each case through certain variables, and they fed these variables and features to the machine. The purpose of this study was twofold. They tried to predict with a high level of accuracy the outcome of each case, and they also tried to predict what would the vote of each Supreme Court justice would be. Now, overall, this model predicted the votes of the individual justices to 71.9% accuracy, and the outcome of the decisions to 70.2% accuracy. But without going into too much detail, I would say that this study is once again not of much use in the arbitration context. Let me explain. So, as with most countries' Supreme Courts, they usually lack an original jurisdiction, or they've got very limited original jurisdiction. The principal role of Supreme Courts in most jurisdictions is to consider appeals from the Court of Appeal or the lower tribunals, which means the Supreme Court is tasked with the obligation of deciding if a piece of law has been applied correctly or wrongly in the lower courts. But when you look at how lower courts approach cases, it's more fact-driven as opposed to being legally principled. Now, in the context of arbitration, as all of you would know, there's no hierarchy where there's a lower tribunal and higher tribunal of arbitration. There's one tribunal which applies, which studies the facts, hears the arguments, applies the law, and pronounces the judgment. And if you are unhappy with it's binding, so if you are unhappy with the outcome, you are allowed to appeal against it in very limited circumstances to the courts. So the point here is that arbitration is a one-stop shop where there's no hierarchy. So the study that we just looked at talks about how the Supreme Court had to binarily decide whether the lower court applied the law correctly or wrongly, whereas arbitration is a far more complex process. So while these two studies can be used to argue that outcomes can be predicted in the legal context, within the very specific context of arbitration, machine learning and artificial intelligence is still not easily transposable. Now that brings us to the more important aspect of an arbitrator, which is the legal decision-making process. Like the main job of an arbitrator is to resolve the dispute and provide the parties with a legal reasoning for the decision he's taken. Now, there are four main limitations here, once again, in implementing AI successfully. The first one deals with what I call the volume limitation. Now, we talked about how there's a scarcity of data available owing to confidentiality. Now, imagine that there is case data which is available. Even when you have data available, it's very important that you have a sufficiently large sample size that can be fed to the machine. In the context of international investment arbitration, there's roughly 60 new cases every year. So we can imagine, we can assume that there will be around 50 to 60 new arbitral awards given every year in the context of international investment arbitration. So when you have 50 to 60 awards, that's a very paltry sum, and you can't exactly feed this as a sample size to AI. So even if AI has been developed to provide you with legal decision making accurately, within the arbitration context, you don't have enough data to feed it. Secondly, what I call, the second limitation is what I call the variety limitation. Now, there's a question in AI as to whether AI technologies require large amounts of repetitive data with binary outcomes, or can AI handle complex data which is non-repetitive? At present, machine learning is the principal form of AI that's going on around the world. And when we talk about machine learning is more effective when you feed the machine repetitive data as opposed to complex and novel data. So when we talk about arbitration, International investment arbitration it's quite repetitive. You deal with the same issues over and over again, like state expropriation of your investors' assets. But in the context of international commercial arbitration, you tend to face a lot of novel and unique issues. So the point here is that AI can be implemented to provide you with legal decision making in the context of investment arbitration, but not necessarily commercial arbitration. Now, the third limitation is the speed of policy limitation. Be it arbitrators or AI algorithms, it is crucial that you keep up with policy updates and changes in the law. For example, the Court of Justice of the European Union, in the case of Chinniah, they fundamentally changed the compatibility of investor-state arbitration with European law overnight, which means that the next day you have to start advising your clients on the changes that they should comply with. Now, in the context of AI, once again, we go back to the scarcity of data. You might have a case in 2013 and the next case in 2016. Too few and far in between. So what happens is that the policy might have changed in between 2013 and 2016. So even if the software can provide you with legal reasoning, the legal reasoning it provides you with would be flawed because it's failed to take into account the change in the policy. If, say, you've got hundreds and thousands of cases that you feed to the machine, it would be able to understand that the policy has changed. But when you have one or two cases dealing with the changed policy, the machine would fail to extrapolate that and apply it. So the problem is that in the context of international arbitration, once again, scarcity of data and scarcity of the number of cases makes it a misfit for AI to be applied in arbitration. Now, fourthly, and this is the biggest limitation that we should talk about, this applies to both peripheral aspects and core aspects, but I thought of covering it now. Now, previously I did tell you how AI can be used to overcome arbitrator bias, but at the same time, there's a strong point to be made that machines can perpetrate bias and prejudice. Now, the popular belief is that machines are emotion neutral, so they tend to overcome pretty much every single bias that's haunting the human world, but that's not true. Take the example of the sensitive data, like the gender of the arbitrator or the sexual orientation. Now, you might hide all of these and input the data into the machine, but what happens today with machine learning is that they can reconstruct all of this information using proxy variables. So I might not need to tell somebody that the particular data that I'm feeding this machine comes from a female arbitrator, but this machine can reconstruct this information and identify that it comes from a female arbitrator. A popular example like I can give you here is that of chatbot Tay, which it's an artificial intelligence chatbot and was trying to engage with netizens on Twitter, and it started espousing profanities. A more disturbing example is that an artificial intelligence software was able to judge the sexual orientation of people based on their publicly posted profile pictures. And this was 83% accurate for women and 91% accurate for men. So what I'm talking about here is that we can't blindly rely on AI, hoping that it overcomes all of these biases. The problem is that when you have a human programmer coding into a machine a particular program, and if that program is biased, you know the problem lies with the human programmer, and you can change the program. With artificial intelligence, you pretty much don't find out for a very long time that the machine that is learning is becoming a very biased and prejudiced machine. So once again, if there's blind reliance on the legal reasons given to you by the algorithm, there's a good chance that you will be falling prey to bias once again. And that's not exactly what you're looking for when you're trying to incorporate AI into arbitration. Now, in arbitration, in the context of arbitration, legal reasoning is extremely important. And I can give you three quick reasons for that. The first reason is what we call the legitimacy objective, where when a party loses the arbitration proceeding, legal reasoning helps that party understand why it lost. Secondly, where this award is published publicly, third parties can learn from the outcome and adapt their behavior accordingly. This is what we call the incentive objective. And thirdly, consistency objective. Fellow decision makers can learn from the rationale in these cases and apply this rationale in like cases in the future. Now, it is true that in arbitration, there's no concept, there's not a concept of doctrinal precedent, but most arbitrators out of good practice do tend to refer to previous arbitration awards before they decide a case. So the problem is that AI, as it stands today, is likely to fail a large number of these objectives. And I would like to conclude that AI, as it stands today, might not be a very good fit when you're expecting the AI to perform the core functions of arbitration. Now, with that, I'm going to come to the final part of my lecture. I'm just going to give you some personal comments, which are outside my professional research. So, in my opinion, technology is inevitable, and we should always welcome innovations which can augment our professional and personal lives. In such a capacity, AI is definitely the next big thing. Because while AI has been a topic that's been theoretically discussed from 1990s or as 1956, as Mr. Anand said, but in the last few years, there's been a quantum leap in the amount of research and money that has been invested in this technology. The number of law firms that have been using AI today have exponentially increased compared to just a few years ago. So it is agreed that AI is a new tool that we should learn and incorporate into our legal practice, be it arbitration or litigation. But having said that, it is my opinion that AI at present falls short of being that paradigm shift that a lot of people expect it to be, at least within the legal industry. Because at present, it fails to be that tool. It still behaves like a tool that a lawyer can use, as opposed to behaving like an intelligent being that can operate side by side with the arbitrator. The last thing I would like to say is that I should put out a disclaimer here. We talk about Moore's law and Fire's law. Technology has a knack for surprising us and catching us completely off guard. There could be a major breakthrough in AI research within the next couple of years, which would possibly nullify everything I've told you in the last 45 minutes or 1 hour. So we can never close the door on technology and walk off with a rigid perspective and understanding. So if I were to leave you with anything at the end of this webinar, I would like to impart the thought that technology is a fluid entity and it can catch up with human intelligence in no time. And when it does, we should be prepared for that. I hope I've made this an interesting lecture for all of you and I've given you good food for thought. Thank you so much, and I'm open to questions now.
Mr. Ramanathan, that was an excellent presentation. And from what you are saying, we come to know that AI has not yet come, but it says, hey, I'm very much there. I'm going to take over at any point of time. With that, you can stop sharing your thing so that your video will be screen. Your screen sharing, you can stop.
Yeah, just give me a minute. I'm doing great.
Yeah. When the speaker is shifting to the video mode, I request all the participants to fill up the feedback form which is posted in the chat box. And we have a question from Mr. Anand.
Yeah.
I will read the question, rather it will be easier for me to do that. Justice is not a simple algorithm. It is a real human virtue, which to be put into practice needs a complex analysis of situation and circumstances surrounding a specific case, as well as of the facts and the application of law. To be able to strike a balance, machines do not have the feeling, empathy, or an idea of justice that goes beyond the processed data and precedent. This may lead to a correct but unfair decision. Your comments on
that?
You need to switch on your video also.
It's not letting me switch on.
Is it?
Yeah. No problem. I'll just speak. What was that? If I best understand the question, it's something about whether it is fair to implement AI when AI machines don't have ethics. Is that it?
By and large, what he says is whatever the situation arises, after all, AI is going to be a machine. It cannot understand the nuances of what the people, their sentiments are, and there could be a judgment, but then it would not be an utter immediate justice. Say, for instance, in case of equity or something like that, you cannot judge based on that.
Yeah, I mean, what I would say to that is that as you might have interacted with many justices and judges, they don't operate on the basis of feeling, except a few judges like Lord Denning in the UK, for example. So most judges don't operate on the basis of feeling, but they operate on the black letter law and precedent. And equity is not exactly a feeling as opposed to being a legal concept. So in that case, I think machines could do a good job if they do develop the way we hope they develop.
Apart from that, in chat box, we have got an array of appreciation for your presentation.
Yeah,
There is one person, Mr. Sugavanam, who has raised his hand.
Yeah.
I'll unmute him.
Yeah, sure.
Mr. Sugavanam, I have unmuted you. You have to unmute yourself. And if you have any questions, you may raise. Mr. Sugavanam, are you there? Okay, I think there should be some mistake there. So that's been raised.
Another question from Shobha Bhavikati.
Yes, I'm coming to that. Her question is, if AI is applied to judiciary, what would be the outcome?
At present, it would be the same as what we talked about in the second part of the webinar. AI is a poor replacement for arbitrators. It can help the arbitrator, but it can't exactly arbitrate. So the same way, I think at present, AI perhaps can help the judge. Maybe it can tell the judge, there's an 86% likelihood that you should decide this case a certain way, but it can't make the decision for him. And it certainly can't make the decision intelligently for the judge. So at present, I think it would be an administrative tool in the judiciary as well.
I think we have no further questions.
Fantastic.
Yeah. So with that, we come to the completion of this. Now I call upon, before that, I would like to make an announcement with respect to the event that is to be taking place in the next coming week. That is week falling on
10th July.
Friday, 10th July, sorry, 10th July. It will be addressed by Mr. Neil Brown. And he will be talking on the subject
Domain names and arbitration.
Yeah, sorry. Thanks, Arvind, for that. Domain names and arbitration. And that will be the, by the way, now we have one more question which has come down. Does AI play a crucial role of tribunal secretary in future? This is by Nityananda. Okay.
Yeah, I do think AI could be used to increasingly replace tribunal secretaries in the future. And my guess is that it could start happening in the next 5 or so years when AI starts becoming a viable technology. Right now, I don't think tribunal secretaries have to worry too much because it's an expensive technology. Very few people use it. But once it's viable, I think it could replace the secretaries.
The program that I was talking is on 10th of July. It is going to be by Honorable Neil Brown, QC, on the topic domain name disputes and arbitration. The program will be at on Friday. You will get your invites in due course. Please do attend. And now I call upon Vaishnavi to render her vote of thanks.
Greetings to one and all. Amalgamation of artificial intelligence and international arbitration is a subject of recent discussion, and the topic has been rightly justified by the speaker. So to summarize the session, the speaker spoke about, firstly, he started with the live example of how we are using artificial intelligence in day-to-day life, and then he gave an overview of artificial intelligence, and he spoke about the extensiveness of the artificial intelligence. Then he spoke about the peripheral aspects and core aspects of arbitration. Further, he gave a special focus on predictive coding and its usage in English and US courts. And he further dealt with the efficacy of artificial intelligence in the field of law and the drawbacks that has to be overcome, and concluded by sharing his constructive views over the current scenario of artificial intelligence in the legal industry. So the topic of today's webinar is an imperative topic, and I thank Mr. Ramanathan Chinniah for giving us an insight over the same. And I thank CNICA for organizing an effective webinar amidst the pandemic. Further, I extend my thanks to the wonderful participants without whom it wouldn't have been successful. Lastly, I extend my sincere gratitude to CNICA for giving an opportunity to render the vote of thanks for today's evening. Thank you.
It was very nice of you, Vaishnavi. Very well spoken, and a very neat sum up also. With that, shall I take the permission of all of you all to end the today's meeting?
Yes. Thank you so much.
Thank you, Ashok.
Thank you. Thank you.